All right, we'll go ahead and get started. I'd like to welcome you all to the second annual Washburn Law Journal Student Scholarship Series. The Journal started this as a means to showcase the work and the effort that our writers have put in the event that they didn't make publication and get published, but they still, all of our writers put in a great amount of time and become very familiar with an area of law. So this is one way for us to allow them to share what they've learned and to allow you guys to take in what they've learned. They'll each be speaking briefly and then take questions at the end. So, Jordan.
I just want to extend my thank yous as well for coming and supporting all the writers as we also get a chance to just present what we spent probably 6 months researching and writing about. As Aaron said, my name is Jordan Duncan. I'm a second year here at Washburn, and I wrote my comment over Florida versus Jardines, which was a Supreme Court case that came out in March of 2013. So in the Jardines case, there was an anonymous tip to the Miami-Dade Police Department that Jardines was growing marijuana in his home. This came through Crime Stoppers in November of 2006. And then the following month, in December, the officers set up an investigation outside of his home, using federal officers and state officers. And then 2 agents, who were accompanied by Frankie, a drug-sniffing dog, approached the home through the driveway, the sidewalk, and then up to the front porch, which was kind of a covered front porch. And Frankie began to alert to the smell of narcotics, and as soon as he did, the officers left and used that alert as probable cause to get search warrant to search the home. Upon searching the home, they found over 150 marijuana plants and Jardines fleeing out the back door. Obviously, he was arrested and charged, and then he filed a motion to suppress the marijuana found by the drug-sniffing dog as a violation of his Fourth Amendment rights. Now, this case got quite a bit of attention. As you can see, it went through the trial court, Florida Court of Appeals, the Florida Supreme Court, and the United States Supreme Court, which all kind of went back and forth and finally determined that, yes, you needed probable cause to use a drug-sniffing dog at the front door. The issue that was presented to the Supreme Court was whether probable cause is needed to allow a drug-sniffing dog to sniff at the front door of a suspected marijuana grow house. And the answer, obviously, was yes. But before we get to that, my arguments were that the property-based analysis of the majority was inconsistent with prior Supreme Court case law regarding police searching techniques, as well as left a discrepancy between the treatment of multi-unit homes and single-unit homes. And my response to that was that the concurrent privacy-based approach actually comes to the same conclusion, but then doesn't have the same problems as the majority's property-based analysis. But before we get to the argument, we have to really understand criminal procedure. So I'm going to try to give you a 101 in under 5 minutes. But first we have to ask, what is a search? And when we ask that question, we realize that there's been multiple tests used. And the first test that was really important, we can see in Olmstead from 1928, and it said that unless there's been an official search of a person or physical intrusion into their home or curtilage, a search hasn't occurred and the Fourth Amendment rights haven't been violated. And that's kind of been the standing ground until we get to 1967 with the landmark Katz case. Now with Katz, the United States Supreme Court declared that the Fourth Amendment protects people, not places. And in the concurrence to the Katz case, we get a 2-part test. So we have to first ask, does the defendant have a subjective expectation of privacy in that item or location? And then will society recognize an objective expectation of privacy in that item or location? And it's usually summarized by, is there a right to privacy, or is there a reasonable expectation of privacy in that location or item? And so then we use that 2-part test until we get to 2012, when we see Jones, which comes to the Supreme Court. And Justice Scalia in Jones first asked, was there physical intrusion? And then he didn't even get to the second part of whether or not there was a reasonable expectation of privacy. In Jones, the officers placed a GPS kind of beeper device at the bottom of a Jeep. And Justice Scalia said, well, obviously, that's a physical intrusion. So we no longer even need to question if he had a reasonable expectation of privacy. And he refused to then make either test an exclusive test when we get to criminal procedure. So beyond that, now we have to realize that there's this wonderful thing called curtilage. Now I know that the home gets the greatest protection under the Fourth Amendment, but there's also this wonderful little bubble that surrounds your house, which is called the curtilage. And that area is the area that immediately surrounds the home, and it's immediately associated with the intimate activities of the home, and so it shares that exact same Fourth Amendment protection as your house itself. And then we have that area outside, which is the outer open fields, and it does not share any of the same protections, and it's usually defined as kind of the underdeveloped area outside of the curtilage. And there's multiple factors in determining, how far the curtilage extends. But one most important thing to note here is that courts have routinely held that an apartment dweller's expectation of privacy and ability to exclude others ends at the interior of their front door. And so we realize that most apartment dwellers who live in multi-unit homes don't have curtilage before they get to their front door. And this is really important when we get to the majority's analysis of the case and then to my arguments. So the next part that we have to understand is the long history use of drug-sniffing dogs and the contraband exception in search procedure. Now the contraband exception says that when there's a test that only reveals the presence or non-presence of a contraband item, it's not a search. And this becomes really important because we have a long line of cases that have held that there is no legitimate expectation of privacy in contraband items. It started out in 1983 when we have Place, and there was a drug-sniffing dog who sniffed luggage at an airport. And while the United States Supreme Court held that the search was unreasonable based on the extended amount of time that it took to get the drug-sniffing dog there, it went on to discuss the actual drug-sniffing dog, which was not even questioned by the parties. And it held that it was not a search. And it said because your luggage is in a public area and you have a decreased expectation of privacy, and because a drug-sniffing dog is sui generis and can only reveal the presence or not presence of contraband items. This was upheld again a year later in Jacobson, where officers used a chemical test to reveal or to discover what a powdery substance was in a package. And the court once again held that there was no legitimate expectation of privacy in a contraband item, and likened the chemical test to the sui generis of the dog sniffs. And then in the Cabayas case in 2005, which is really important, we'll actually come back to it again, it combines the two theories and once again says that there's no expectation of privacy in a contraband item, and that a dog sniff is sui generis, and because it can only reveal that item or that item is not there, it's no longer a search. So what happens when this contraband exception comes to your home? And we see in 2001 we had the United States versus Kayla, and it refused to extend the contraband exception to the home. And Justice Scalia, writing for the majority, said that all details of the home are intimate details, and there needs to be a bright and firm line drawn at the entrance of every house. And so in Kayla, when the officers used a thermal imaging device to look at a row of homes to see which one had the most heat and determine that that must be the marijuana grow house, the court held that a search occurred when the agents used a sense-enhancing technology not in common use by the public to gain information about the inside of a home that otherwise would not have been discoverable. So what's really important about Kayla are the two theories that, one, all details in the home are private and legitimate, and we have to draw a bright and firm line at the front door, and individuals may need protection from sense-enhancing tools that could decrease their Fourth Amendment protection. And like I said, we'll come back to Kayla, and it happened, or Cabayas, and it happened in 2005. And although this happened with a car on a highway, it had the opportunity to make the distinction that the reason why Cabayas was not a search and Kayla was is because one happened in a car and one happened in the home. But instead, the court did not make that distinction very important and decided to argue that a thermal imager device was not sui generis while a drug dog sniff was. And so after 2005, we have this question of whether or not if you use a sui generis test, such as a drug dog, and go to a front door, will it be a search? And we didn't know. So Jardines was the first case that really gave us the chance to come up with that. And just one powerful note to note that the dissents called the infallible drug-sniffing dog a legal fiction, and some courts actually allow the use of drug-sniffing dogs to have a false positive rate as high as 60%, which means that you could actually still be physically intruded upon or have a search even with the use of a sui generis test because it could give a false alert. But anyway, so let's go to the decision of the court. So, well, as I mentioned, Jardines was the newest and first chance to really extend the full force of the protection in Kayla and say that it doesn't matter if you're using a sui generis search tool like a dog, the firm line of the home should stand. But the majority didn't do that. Instead, they removed the question from can a drug dog sniff at the front door to what kind of protection does the curtilage give us? And so the majority used a property-based analysis from Jones and asked, was there a physical intrusion? And to get to the answer, yes, Justice Scalia said that you have express and implied licenses to enter someone's property, and they are limited in time, scope, purpose. But there's no implied license for a police officer to walk up to your front door with the intent to search. Now, what's really important about Justice Scalia's opinion is that he doesn't actually declare the drug dog a search tool, or doesn't actually declare the use of a drug dog a search. He focuses on the fact that the officers had the intent to search the home when they walked through the curtilage. And that was evidenced by bringing a drug-sniffing dog. And it was a very confusing opinion. But anyway, so as we move on to the concurrence used Katz and Kayla to reach the same conclusion as the majority. And they said that, yes, the home has the highest protection. All details of the inside of the home deserve legitimate protection and are intimate details, and we should keep that bright and firm line at the front door. And so to fall under Kayla, the concurrence went ahead and declared that drug-sniffing dogs are a sense-enhancing tool. And so that's very, very important. And so they decided that, yes, a search happened because we used a drug-sniffing dog to figure out what's on the inside of the home which would otherwise not have been discoverable. So my argument here was that the property-based analysis of the majority to determine whether or not you're exceeding the scope of your license and the curtilage leads us to multiple problems because it diverges from previous case law, really recent case law, that allows officers to be on property. Additionally, it creates a discrepancy in how we treat these multi-unit homes that don't have any curtilage and single-standing homes. So, first I want to bring our attention to, there we go. The knock and talk procedures, which is a criminal procedure that was upheld in Kentucky versus King in 2011. Now, a knock and talk is where an officer approaches a home and wants to speak to the person there. So they'll knock and they may be investigating a crime, maybe asking to get consent into the home, or maybe just want to get to the front porch so they can see what's in plain sight from that vantage point. But what's really important in Kentucky versus King, they said that an officer can do what any other citizen would do. And in that case, they actually compared officers to Girl Scouts selling cookies and salesmen handing out flyers. But what's really important is that the court noted that the Supreme Court has long taken the view that even-handed law enforcement is best achieved by the application of objective standards of conduct rather than standards that depend upon the subjective state of mind of the officer. So in 2011, we uphold the ability for an officer to walk through your curtilage, walk up to your front door, despite what's going on in their head, because they're just doing what a citizen might do. And we don't really know how this is going to be affected after Jardines, because now we say it's a search if they walk through your curtilage, and they want to search. No matter what tool they're using, no tool or not, that if they have the intent to search, they're now outside of their scope to be in your curtilage area. So now we really don't know where the knock and talk procedure stands under the Jardines case law. And the second argument that I had was that it creates a discrepancy between multi-unit homes and single-standing homes. Because we have to remember, the majority's analysis was based on the fact that the officer exceeded his implied scope to enter his property because he had the intent to search. But multiple homes don't actually have that protective curtilage bubble, so now there's nothing to prevent an officer from walking up to the front door without that curtilage. So when we see that many states, Colorado and Maryland are actually two of the most prominent, they even say that locked hallways to an apartment are not curtilage, and that anybody is free to walk among them. And so if you don't have that protective bubble before you get to the front door, we don't know whether or not an officer is still allowed to use a drug-sniffing dog to smell at the front door, because the majority removed the question to are they allowed to be in the curtilage. And this is extremely important because in large cities, up to 50% of housing is comprised by apartments. And so there's a high number of people that may not have protection from drug-sniffing dogs smelling at their front door. Argues that the privacy-based solution, or the privacy-based analysis of the concurrence reaches the same solution, but prevents all of these problems. So we have to remember the concurrence used a three-step approach, where they said, yes, the home has the highest expectation of privacy, and it has the highest level of protection under the Fourth Amendment, and you cannot search there. Because all details inside are intimate, and they're all protected and legitimate, which we get from Kayla. And then we go ahead and declare that a drug-sniffing dog is a sense-enhancing tool under Kayla. And so now all homes, the second that the drug dog sniffs at the front door, it becomes an unwarranted search and a violation of the Fourth Amendment right, no matter whether or not you have courage. And a really important thing, so we're going to see results that drug-sniffing dogs to learn about the inside of a search. So there are a couple things that we really need to keep in mind about this, is that it doesn't matter anymore whether or not you have curtilage, but if you have an entrance to your home, you'd be protected under the concurrence analysis. Additionally, the intent of the officer becomes irrelevant. So we can go back to that Kentucky v. King mindset, and we look at the objective actions and conduct of the officers, which is going up to a front door with a drug-sniffing dog, a tool that's not available to the public. And additionally, we really need to keep in mind that since Kayla only applies to homes, and that bright and firm line is only at the entrance of a house, we're still within the search procedure that exists around dog sniffs, and yet we can see the dog sniffs will still be allowed to be used at cars, luggage, and packages because there's a reduced expectation of privacy in those public arenas. So, with that, I guess I will see if anyone has any questions. Yes, Professor.
So the privacy-based approach intuitively makes more sense to me.
Yeah.
I am less moved by the disparity between single-family unit dwellers and apartment unit dwellers. I guess, why is that important? Why should I care about that as a further justification for the privacy-based approach?
Well, I mean, the Fourth Amendment protects an individual, and it shouldn't protect about where they live or why they live. And so if you choose to live in an apartment and you don't want to take care of a front lawn, or maybe you can't afford to have an actual freestanding home, it doesn't mean that your rights to be free from government intrusion should be diminished because you live in that area. And so if you don't have that curtilage bubble, Jardines is not providing you any protection.
So under Jardines, the officers can take their drug-sniffing dogs through the hallway of an apartment?
Yes, because the majority's analysis was not whether or not the drug-sniffing dog could sniff at the front door. They removed the question to whether or not the officer was trespassing when he entered Jardines' property. And they said that he trespassed because you only have an implied license to do what other people would do, which is not to walk into your property wanting to search your property. Yes.
Yeah, Jordan, I had a question about the policy reasons behind the property-based justification. Like, obviously, Justice Scalia and the majority espoused the property-based approach, but what was their justification? Did they give a justification?
They did not.
Okay.
I don't know if it was just because he had just decided Jones the year before and was really excited to use this new physical intrusion test that they haven't used since 1967. But you know, he writes a lot of opinions, so I'm not exactly sure why they used that analysis. Yes.
Would it make a difference if there's a doorman downstairs that would physically prevent or would tell the police officers to sawed off?
That I'm not sure. A couple of states have said that even a locked hallway isn't curtilage, because as long as someone can let the officer in, then they have the ability to be there. Because if you live in an apartment, you don't have exclusive right to the hallway, the lobbies, the basement. And so even if one person says no, the other person says yes, then they can come on in. Yes.
Did the majority in Jardines overrule Katz?
It did not.
Okay, so I guess my question is, why is it either or and not both and?
Justice Scalia said in Jones that he was first going to question whether or not there was a physical intrusion. And if the answer to that was yes, then there was no need to go to the second test.
Then there's no need to, but you're posing this as either or. You either need one or the other. Why can't it be both? We're going to give the most protection from the Fourth Amendment using both tests.
No, I didn't really think about it that way. I just didn't like the idea that we're going to be so subjective about the intent of the officers when we haven't done that before. And so even if we use both the physical intrusion test, we still have to figure out what's going on inside the officer's mind. And the only evidence of that is whether or not they're bringing a tool and what questions they ask. And we found through Kentucky versus King that that is not the best approach to determine whether or not searches occurred.
All right, thank you.
First of all, I'd like to, again, thank everybody for coming, but I would like to express my thanks to Professor Hodgkinson for letting me write about the case he argued last year before the Kansas Court of Appeals. I'd also like to thank Professor Ramirez and Professor Kay for providing feedback, and also my editor, Nate Doherty, for being able to help me through this process, and the entire journal board for giving me the opportunity to present today. So today I'm going to talk about cell phone searches. How many of you have a password on your cell phone? So just so you know, it doesn't stop the police from searching it. We're going to talk about State v. James. It's a cell phone search case. James was on his way home from a date in Emporia. He was with his girlfriend in the car when he was pulled over by the police for a burnt out headlight. Without asking, James stepped out of the police car and started engaging with the officer. Officer smelled alcohol in his breath. James denied drinking any alcohol, but the officer went ahead and searched the vehicle for open container. He found a cup in the console with alcohol in it, and then proceeded to search for more evidence of open container. Found an open bottle of E&J brandy, I believe, under the back seat, and then proceeded to search the glove box where, surprise, surprise, he found a half pound of marijuana in the glove box with some scales that measured up to an ounce. So with that, James was arrested for possession of marijuana. The officer placed him in handcuffs and asked him, "Who does this weed belong to?" James denied any knowledge of it and said, "It could possibly belong to my brother. Why don't you call him and see if he'll fess up to it?" Smart move. He stuck out his hip, and the officer reached into his front pocket to pull out his cell phone and proceeded to go straight towards the text messages, did not even call his brother to figure out if it belonged to him or not. In the text messages, he found two suspicious ones, one that referred to, "Hey T-Ray, you got a 20, or "Hey T-Ray, you got some green, I have a 20, and other messages to that sort from the day before. So he was arrested on the drug charges and was convicted of them. So he appealed, and in the appeal, he argued that it was a violation of the Fourth Amendment. It was an unlawful search of his cell phone's text messages. And to go through that argument, we again have to revisit the Lovely Cats case, which established a reasonable expectation of privacy standard. We have Justice Harlan's concurring opinion, which laid out the two prongs of it. The person must have a subjective expectation of privacy, and that expectation of privacy is one that society is willing to protect. From there, we get a long travel of Chamel and Robinson that expands the search incident to arrest doctrine. The officers can only search the immediate surrounding area of the person. Then it expands to vehicles, and it goes to trunks, and then it can search the entire passenger compartment of the vehicle, which is where we are today. James was outside of his vehicle, but his cell phone was on his person. So the court decided that it was a valid search incident to arrest because he was arrested for suspicion of drugs, and they were trying to figure out to whom the drugs belonged to, so the officer was entitled to find probative evidence of that arrest. The court followed the reasoning of Robinson, that it was reasonable, and the interesting twist in all of this is that the court agreed that cell phones are becoming more like computers today, which leads me to where my main argument is, or main focus of this presentation is going to be. I raised 6 arguments in my comment that cell phones today are more like computers, that the detective went outside the scope of consent given. There's an untrue presumption that the evidence was going to be destroyed, therefore facilitating the necessity to search the cell phone. There's trends emerging in different states and different circuits regarding cell phones. And then the problem with the Kansas suggestion to fix how to protect your cell phone from unreasonable searches and seizures, and then the swing back to the trespass doctrine, which Jordan covered in Jardines. So I'm going to focus on cell phones today are more like computers than cell phones. The first cell phone call was placed in April of 1973. And since then, we have been able to do anything that you can possibly imagine. We can place phone calls, we can text, we can surf the internet, we can send videos to each other halfway around the world. However, the Supreme Court and other state courts have not kept up with the times. Today, the Kansas Court of Appeals stated that cell phones that are not smartphones aren't afforded the same protection as smartphones. The court said that they thought that James's cell phone was not a smartphone because it was a flip phone, that they couldn't tell from the video whether or not it was a smartphone. So I argue that we need to err on the side of caution and that all cell phones just should be protected under the Fourth Amendment. To support that, I argue that James's cell phone actually probably could have been a smartphone. How many of you had a Motorola Razr when you were younger, like 2006? Or something comparable, a Sliver, a BlackBerry, one of those kind of devices. Well, it might be surprising to you, but actually all of those are smartphones under the 2010 definition of smartphone. PC World magazine defined smartphone as anything that has built-in applications and internet access. That means that it can provide a digital service of text messages, email, web browsing, still camera, video camera, MP3 player, video player, television, organizer, Now I remember in 9th grade when I had my Motorola Razr, I was getting in a lot of trouble because I downloaded those songs and applications and games from the internet on it. Well, the Motorola Razr came out in 2004. So the court, did I say something bad?
We're just all feeling very old.
I apologize. So in 2004, we had these smartphones out here. However, the court didn't even dive into whether James even had a smartphone and just presumed that his phone was not a smartphone because it was a flip phone. Well, Motorola Razr is a flip phone. So we can't sit here and judge a book by its cover. We can't just say, oh, the video looks like it's a flip phone, it's not a smartphone, so therefore it's not a smartphone. The court said that, smartphones are a lot like computers, and in Kansas, computers are protected from unreasonable searches and seizures as well, and officers need to have a warrant to search them. So because they aren't able to tell if it is a smartphone or not, we need to go ahead and provide it the protection equal to a smartphone and err on the side of caution. Now, other states are dealing with this issue as well. Ohio just recently came out in their decision that a cell phone or smartphone is protected under the Constitution, that it's not a container under Belton, so therefore there's no justification to search it because it's not capable of holding anything else, another object, which is what Belton says. However, California, they take a different approach. They follow our approach in saying that, we don't need to give cell phones protection. I mean, they don't have a reasonable expectation of privacy. However, today you can link your cell phones to different servers and clouds and other mobile devices. Therefore, you should be able to have the same protection you would a laptop because, let's face it, we're driving down the highway, we get pulled over for speeding, cops has reasonable suspicion for some reason to search our vehicle, ask to see our cell phone, and we're all attorneys, so we have a lot of stuff on our cell phones. So what happens if the officer searches our cell phone? Do we just corrupt all of our confidential client information? Our cell phones are linked to our servers at the office, so therefore we should have a reasonable expectation of privacy in them. So that's my argument on why the Court of Appeals got that section of their argument wrong, is that we can't look at just what a cell phone looks like. We have to look and delve into what does the cell phone do, when was it made, how the person uses it. We can't just put a blanket category of smartphones and non-smartphones out there, because then it eats into the police efficiency and all of the things that we're trying to protect. So with that, I'll take any questions. Professor Glasshauser?
I'm very curious about the distinction between smartphones and non-smartphones. I happen to have a non-smartphone.
Does it get on the internet?
No, it doesn't. I mean, it sends text, but I guess I wonder why I should have less protection. And let's say even before any sort of cell phone was around, do you know whether, I just don't know the answer to this, if the police wanted to search your phone records, just from an old landline, if they wanted to go search those, would they need to have probable cause for that?
I believe they would need probable cause for that. That goes back to this Maryland v. Smith, where you don't have a reasonable expectation in the numbers that are dialed. You have a reasonable expectation in the conversations that you have, though.
Oh, but not in the numbers.
But not in the numbers you dial.
So I guess for a non-smartphone, the theory would be then there's really nothing
to
substantive
protect
on here.
Yeah.
So the numbers I chose to dial are not.
Correct. It would be similar to a pager.
Well, that's the text.
Yeah. So, like, if it's like a pager, then you don't have that. So, yeah. Any others? Yes.
So just to follow up on Professor Westler's question. So if you had a phone that sent a text message, is that considered a smartphone under this distinction right now, or is that unclear?
No, I don't think it would, because the definition that I used from 2010 gives a list of different applications. It doesn't need to have all of them, but it needs to be something similar where you could go into your web store on your phone and download different applications or something like that.
So under the current test, if you have a smartphone, it has enough of those applications, then the whole thing's protected. But if you don't have enough, you're in your Alex and you only have text messaging, then anyone could, then the policeman can search it.
Under my argument, yes, actually the Kansas Court of Appeals didn't lay out any sort of test. We have no test. They just basically created open season on cell phones. So, like,
Did the court say that, well, did the court uphold the officer's statement that he was concerned that the evidence would be destroyed in deleting the text message? Did they find that to be?
they didn't get to that point. That's where I went a little more broad in my comment. I didn't focus solely on the consent. Other circuits and other state courts have had this come up in their usage and defending these kind of cell phone searches. So I just wanted to give a nice rounded view.
I'm curious
of what's
because
happening.
the phone companies actually do keep records of individual text messages and
Yes.
content, not just where it's going and where it's from.
Yes, I actually proposed that as one of my solutions. If they were afraid of the information getting deleted, they could contact the cell phone company and get it. However, they would have to know the cell phone company, and I think they just need to know the cell phone company because they have different retention rates. So I think Verizon is like 30 days and US Cellular is 60 days and stuff like that. So you would have to know the company for sure.
You said that even if I had a password that I'm still not protected
Yes.
here. So does that mean that I would have to give the officer my password?
There's cases out there because Belton provides that an officer may search any container within a vehicle. It has been expanded to locked containers as well. They can break into a glove box that's locked or briefcases that are locked. So if you have a cell phone that has a password on it, there is the theory out there that the officer can try to crack your cell phone code to get into your cell phone messages.
Until it clears my entire.
Yeah. But there's more reasonable ways to get the information, so, yes.
Thank you.
You know, they say in PowerPoint 101 to use a catchy slide, so to start with. So I figure you throw Che Guevara up there, you'll incite some emotions one way or another. So thanks for coming out. I'm actually happy to see that a lot of the audience is professors because you guys ask us questions that we don't know the answers to all the time. So this should be business as usual. Okay, here's just a quick agenda. I'm going to go through some of this stuff pretty fast, and then hopefully we'll have some time at the end for questions. But before we get started, here's a quote that came from the Justice Alito opinion in Salinas versus Texas, which talked about your right to silence in pre-arrest, pre-Miranda situations. And particularly, there's a dynamic of this, what Justice Alito calls a popular misconception, but the literature calls lay opinion and what most people believe, that in order to exercise your right to remain silent, all you have to do is, well, remain silent. And I know that that's really revolutionary, but that's what most people believe. And the question is, when legal precedent doesn't necessarily match up with uncontroversial lay opinion, shouldn't that lay opinion get weight? Shouldn't that matter in the court's decision? And then that's kind of a dynamic running through both the Alito opinion and then Justice Breyer's dissent. So just something to think about as we go along. The facts in this case are fairly simple, nothing too special. There was a Houston, Texas murder. Two brothers, Juan and Hector Garza, were murdered in their apartment. Obviously, police investigated that, and they located 6 shotgun shells. Further investigation led them to Mr. Salinas. They went to his home where he lived with his mother and father. They asked the father for permission to search. He said, sure, no problem. Searched the house. They found a shotgun. They asked, can we take the shotgun for ballistics testing? Father said, sure, no problem. Then they asked Salinas, would you mind coming down to the station and talking to us? And Salinas voluntarily went with the police and was subjected to a 58-minute interview or interrogation, depending on how you look at it. Halfway during the interaction with police, the question was asked, are the shotgun shells we found going to match the shotgun that we recovered from your father's house? At which point, he said nothing. He just looked at the floor and said nothing. They asked him follow-up questions. He answered all those. He answered all the questions before that, but he remained silent at that one question. At trial, the detective testified to those facts, and Salinas didn't testify. And so the prosecutor, during closing arguments, quoted, when asked that question, an innocent person is going to say, what are you talking about? I didn't do that. So, and that was objected to by the defense, and the judge said, no, the jury can infer guilt from his silence because it was prior to arrest, prior to Miranda, so there was no harm, no foul. And on we go. Now, a little background about self-incrimination is there's a fairly rich history in going back all the way to ancient Jewish law. The problem is there's very little history when the Fifth Amendment was actually created. And we don't really know what the framers of the Fifth Amendment believed the privilege against self-incrimination to be. If you look at Jefferson, for example, he said, well, we're really prohibiting torture. We don't want people to be tortured. Some of the writings of Ben Franklin said, no, we're really talking about self-accusation. But the privilege was kind of an artifact of British common law rule. So the appearance, at least, is that the drafters of the Fifth Amendment just adopted it without a whole lot of thought and without really specifying what it means. One of the first cases that looks at this is Marbury versus Madison, which we all know is important for judicial review, but it actually talks a little bit about the Fifth Amendment. And that case seemed to believe that we're really protecting something in here. We're not really sure. And that continues to grow as we're expanding the Fifth Amendment, the right against self-incrimination, but we're not really defining what it applies to until we get to Miranda. And Miranda says you have a right to remain silent. Well, Miranda, if you read that opinion, draws a lot of its rationale back to English common law courts, which by the 1600s or so, that's the general idea, at least the Puritans were raising, was that, well, we're really protecting a right to remain silent here. And now that you have that right, obviously crafty prosecutors want to know how to use it against you. So if we think about a criminal case, there's four kind of delineating points we can look at. There's an interaction with the police. At some point there's an arrest. There's Miranda warnings given, and then you have a trial. Okay? At least this is how most of these cases worked out. There's two ways prosecutors found that we can use silence against you. We can either use it to impeach you, to draw up an inconsistency in your statements. And generally the way that would work is you raise an affirmative defense at trial, such as self-defense, and the prosecutor says, well, you didn't talk about self-defense when we were questioning you before the trial, so obviously there's an inconsistency here, and we're going to try to use that against you. Generally speaking, the court held that once Miranda warnings are given, that's kind of it. You can't use someone's silence to impeach them. Prior to Miranda warnings being given, it's generally okay. A key kind of note here is the time span, just as a practical matter, between arrest and being given your Miranda rights is generally very short. So there's not a whole lot of litigation kind of in this area. It's either dealing with pre-arrest or after arrest. So how do you keep the prosecution from using your silence to impeach you? Well, you don't testify at trial, and then that kind of keeps them from being able to use it. So crafty prosecutors again said, okay, well, if you're not going to testify and not let me impeach you, then I'll just use your silence as evidence in the case in chief to infer guilt. And the court held, well, if you choose not to testify at trial, that can't be used against you. And in a fairly narrow holding that's not 100% clear, Wainwright v. Greenfield, the general idea is post-Miranda silence can't be used as evidence of your guilt. So Salinas fell into this category back here. Well, what if you haven't been arrested and you haven't been given your Miranda warnings? Can that be used against you as evidence in the state's case in chief. The circuits, obviously there was a pretty big split here. The circuits outlined in red had said, no, you can't use silence against someone in the case in chief. The circuits in green said you could. Interestingly, the Ninth Circuit in 1978 originally said no, but then in 1998 changed their mind. So the Supreme Court took the case to determine whether pre-arrest, pre-Miranda silence can be used in the case in chief. What did they say? We're going to get sidetracked and not really look at that issue. So what ended up happening actually is the question became not whether you have a right to silence in those situations, but how do you invoke your right to silence? It was a plurality opinion, a 3-2-4 split. Justice Alito said that in order to rely on the privilege of self-incrimination, you have to expressly invoke it. Okay? Interestingly, he didn't say whether or not you have the privilege. He just kind of said, well, if you do, you have to invoke it properly, and we're not really going to tell you how you have to invoke it. So that's obviously a point for other litigation. I didn't focus much on the Thomas concurrence. It generally is consistent with most of his opinions recently that will just do away with 200 years of precedent and rewrite everything. And then finally, the dissent was pretty clear about not only do you have a right, but this is how you invoke it. And they outlined a 3-part test. And this is really where my argument and research looked at, particularly the defining factor here is notice. In order to invoke a privilege or a right, you have to notify the state that you're going to give that. The question, and where the differentiation became, was, is that notice based on some legal construct that we've identified and put together, or should it be based on circumstances? And the dissent said it should be based on circumstances. If the police ask someone, did you murder person X, they're looking for a self-incriminating response. You don't have to say, I'm invoking my right to silence, because they can infer from the fact that you didn't respond to that question that it's a self-incriminating response. On the contrary, the majority, or the Alito opinion at least, says, well, the right to silence isn't just an unqualified position. You just remain silent whenever you want. It's only when you're protecting yourself from compelled self-incrimination. So theoretically, I could be compelled to testify that Kayla murdered someone, but I can't be compelled to say that I murdered someone. So the state's, or the Alito opinion at least says, well, the state needs to know why you're invoking your rights. Well, that, to me, at least my argument was, it goes back to who's controlling these interviews. Obviously, it's the police. The police know what information they want. They wouldn't come and get you and talk to you unless they knew what they wanted from you. So if they know what they want from you, and they ask you questions that are geared at getting you to incriminate yourself, obviously your responses in remaining silent are putting them on notice and showing them why you're invoking your right to silence. Further, is there a good reason to excuse it anyway? And really this is, again, more of a pragmatic look at things, in which I argued that this voluntariness standard, that you're free to leave just because you're not under arrest, is really a legal fiction, in my opinion. People generally are not going to, in the middle of the interview with police, stand up and say, well, you know what, I'm done talking with you, I'm going to go home. Obviously, it's going to draw attention to you. Most people are somewhat have a fear of the police. There's studies that show that that's just not going to happen. And so this idea that police and citizens are on equal footing is just not realistic. And the circumstances-based approach accounts for that, and I think is more important. Finally, there's this question of really and truly wrapping this all up. What do we do about this? Well, I argued that evidentiary codes should prohibit use of silence in general. Silence is generally understood by academics and legal scholars to have very high prejudicial value and very, very low probative weight. All it proves is that you were asked a question that for whatever reason, whether guilt or embarrassment or ridicule or whatever, there was a question you were asked that you didn't want to answer. That's all that it proves. However, studies also show that just about any time that silence is used, the jury will infer guilt from it. So that sums up my comment. Is there any questions? I know we've probably run over a little bit. Okay. Well, thank you all for coming out.